Good morning, everyone. We're going to get started in just a minute. While we're waiting, please feel free to introduce yourself in the chat box.
Jennifer, just to test on my audio.
It sounds great, Joan. All right. Okay, so in the interest of time, I'm going to get started. I'm Jennifer Clark, the Manager of Programs and Operations at the New York State Coalition Against Domestic Violence. My pronouns are she, they, and welcome to this morning's webinar on the 2022 Legislative Session Review webinar. Before I hand things over to the Director of Public Policy and Advocacy, Joan Gerhardt, for today's presentation, we're going to go over just a few housekeeping items. This is a webinar platform, so for that reason, all lines will be muted and we will not be unmuting anyone for any questions or comments. So we do ask for that reason that you use the chat box or the Q&A feature, as we will be having our Public Policy Coordinator, Brittany Galati, on hand to answer any questions or read them out. We will have some time at the end for question and answer regarding any of the legislative and policy updates that Joan is giving. We are recording today's session, and a copy of that recording will be available shortly after today's presentation. We also have live captioners for today's session, which you can turn on and off utilizing the buttons in your toolbar. It should either be an icon in the bottom, or by clicking that More button, you should be able to turn them on and off. And we will also make sure that in addition to the recording, you also get a copy of the presentation slides. And with that, let me hand it over to Director of Public Policy and Advocacy, Joan Gerhardt.
Thank you, Jennifer, and good morning, everyone. Brittany and I are here back in the office today, first time in at least 18 months, if not longer. So happy to be back and be with all of you today. So I'd like to again welcome you to today's webinar. We're going to be talking about the 2022 legislative session, both the budget process as well as legislation that has been signed into law or may be signed into law by the end of the year. So we've got a lot to cover today. I'm going to be moving very quickly, which I apologize for in advance. But as you see, we have a lot to cover. We're going to be starting with the 2022-23 state budget, and we'll be talking first about the specific appropriations that are important for our community to know about, and then turn to the Article 7 policies, which are embedded within the state budget, introduced by the governor and approved then by the Assembly and Senate, making it into the final budget. After that, we'll be taking a look at legislation that has passed both chambers. Many of those have already been signed into law. We'll cover those first. And then we'll take a look at the bills that passed both chambers that are awaiting the governor's action. And she has until the end of the year to act on all of those remaining bills. And hopefully we'll have time to do a quick wrap up or a look ahead of the 2023 legislative session. Those are my predictions on the interest areas of the legislature and of our community. And finally, we will hopefully have time for a Q&A. As Jennifer said, we won't be taking anyone off mute, but we will be using the chat feature today to see if you have questions and answer them at the end of the webinar. So starting with the budget appropriations, and just a reminder, the budget starts with the executive budget that is introduced in January by the governor. Then the Assembly and Senate have a number of joint budget hearings to review the various budget bills. There are actually several bills that make up the budget. It's not just one colossal budget. It's actually about 8 colossal budgets. So they have joint hearings on each of those. And then each chamber produces a report, essentially a response to the budget. And then that's when the real negotiation begins until we get to April 1st, when that budget is approved. So I wanted to start in our discussion of this year's budget, talking about the additional funding that we were able to get in the budget for the VOCA shortfall. And I think most folks participating in today's webinar probably are familiar with the declining VOCA federal grant that's been coming into New York. In fact, in the last 4 years, it's lost about $150 million of value. So obviously, the state would have to make up that shortfall, or programs, victim assistance providers would be cut substantially. Because of our collective advocacy, our work alongside other coalitions like NYSCADV and the Legal Services Coalition and the Children's Alliance, we were able to get the governor and legislature to assign an additional $14.4 million to OVS. And this is state originating dollars. It comes out of the general fund to cover that VOCA shortfall, at least in the first year of the next grant cycle, which begins September of 2022. Now, I know some of you are probably wondering, well, wait a minute, I just got my award letter from OVS and I've been cut. And we're hearing that some programs have been cut as much as 30% from their prior award. So we're still in a fact-finding sort of area right now. We're trying to understand why programs have been cut so significantly, more than OVS estimated, frankly, before we were able to get the $14.4 million. But you can be sure we'll be advocating for some resolution to ensure our programs are not cut drastically. I mean, obviously, this will significantly impact services to victims across the state. And I'll talk a little bit more about that when we get to our 2023 look ahead. So now back to what was in the budget. We had, again, $66 million assigned in OCFS Title 20 funding. This is for both domestic violence and adult protective services. And this is the funding that goes out to counties and is used to pay the per diem reimbursements for clients who are not TANF eligible. So that sits at $66 million. We also were awarded $3.2 million to OTDA of TANF funding for non-residential domestic violence services. This used to be $3 million. We got a slight bump to 3.2 last year. We've actually been asking for a doubling of this fund to 6 million. So that was not something we got accomplished, but we didn't see a cut. So that's, I guess, something. We continue to see the legislature and governor set aside funding for a pilot at OCFS to study the per diem funding model. This year's budget included an additional $5 million. So we now have an existing pot of $15 million for the pilot program. Still no detail from OCFS on when this pilot will begin or the parameters of the pilot. We're certainly hoping to collaborate with OCFS as they develop that program, but at least the funding has remained. So we're at $15 million. And OCFS got another $10 million for contracts with human services and veterans community services organizations. These organizations were not identified in the budget, so we'll have to wait to hear from OCFS how they intend to distribute this funding. There was additional funding in the budget for a rape kit storage facility. I'd like to just differentiate rape kits from sexual offense evidence collection kits. Same kit, but they're in a different place in the process. So rape kits, as the state refers to them, refers to a kit, an exam, the evidence, the material that's collected during an exam after a sexual assault, but where the victim is not ready to say they want to proceed with a criminal case. So in 2018, the state passed a law that's changed the requirements for storage of these rape kits, which are not yet evidence, from 30 days to 20 years. And the state required the development of a long-term storage plan to be developed. This funding relates to the storage of those kits. So the kits before there's a criminal proceeding that's initiated. And we saw in last year's budget, $4.3 million awarded for an actual storage facility. And we understand that facility will be in Washington County in upstate New York. This year's budget included an additional $1.2 million for that facility, as well as an additional $2.5 million to OVS for administration and staff. I'm going to be talking a little bit later on about the sexual offense evidence collection kits. Another new program that got funded in the budget was $7.3 million to DCJS for a community safety and restorative justice program. And I've listed for you the specific programs that are identified in the budget that could be eligible for this funding. It does include domestic violence and sexual assault programs, legal services, alternatives to incarceration, community supervision and reentry, and the like. And these are programs that are managed by community-based not-for-profits or local governments. So we'll have to wait to hear from DCJS on how they intend to distribute that funding. And there was also a new appropriation for OPDV for a sexual harassment and gender-based violence awareness program. And OPDV has informed us that this appropriation was not requested by OPDV. It was actually included in the budget by the Senate. So the Senate will be communicating with OPDV on its intentions for this program. So more to come on that as well. Some other notable mentions: OCFS received $7.3 million for multidisciplinary child abuse investigation teams and new child advocacy centers around the state. And they also got $2 million for services for sexually exploited youth up to the age of 21. You've probably been hearing about the difficulties, the challenges that some communities, prosecutors have had complying with the new discovery laws that were put in place in 2019 and 2020. This year's budget includes $40 million for upstate communities to implement those discovery laws. I also wanted to mention something that was not in the budget for domestic violence advocates. There was funding for a 5.4% COLA increase for some workers across the state. There was increased pay for home health aides, and there were bonuses for healthcare and mental hygiene workers. And unfortunately, domestic violence advocates were not included in any of these categories. So I'll be talking about this again when we get to the 2023 look ahead. So now I'd like to move on to the policy proposals that were in the budget, starting with the policies that actually were approved and made it into the final budget. So there's a couple of different budget bills that include these policy priorities. The first one I'd like to talk about is the PPGG budget, which stands for the Public Protection and General Government Bill. The first policy that was approved in the final budget relates to victim compensation. This is an important change, and I'm not sure it's gotten a lot of attention. It essentially increases the maximum reimbursement for repair or replacement of essential personal property to $2,500. It used to be only $500. So this would be certainly enough funding to replace someone's phone, which I think was the difficulty with the $500. Another proposal that was approved would provide vital documents, including a copy of their birth certificate, to individuals who are being released from incarceration. And this is really important for those individuals because it will enable them to obtain an identification card, which was very challenging for them to do without these vital documents in hand. Another budget bill is the ELFA bill, and that stands for the Education, Labor, and Family Assistance Bill. There's a few important policy proposals that were approved in the final budget in this bill. The first relates to public benefits and the determinations of eligibility for individuals. So before this proposal, that determination could be made in 45 days. Now, the state has 30 days to inform an individual if they are eligible for public benefits. So that's a really good improvement. The proposal also increases the level of exempt resources that an individual could have while the state calculates the amount of their benefits. So for applicants, the exempt resources used to have a maximum of $2,000. That's been increased to $2,500. For seniors aged 60 plus, there was an increase from $3,000 to $3,750. And the proposal also adds this exemption for individuals who are applying with disabilities. And they also have an exempt level of $3,750. And these changes build on some additional improvements made last year to exempt certain savings from this calculation, savings like college tuition or what you might have in the bank to purchase a car or funding for funeral arrangements. So we're moving in the right direction with respect to eligibility for public benefits. Another important proposal that was approved is something NYSCADV has been advocating for as a legislative bill for several years, and it relates to language access. And this essentially requires all state agencies who are providing direct services to New Yorkers to translate their vital documents into the 12 most common non-English languages. And there's a very specific methodology in the proposal for the state to determine which those 12 languages are. The proposal also requires these state agencies to provide interpretation services to individuals in their primary language when discussing services or benefits. Each agency has to have a language access coordinator and a language access plan, which has to be updated every 2 years. And I think one of the most important elements of this proposal is that it requires employees in state agencies to have an annual training on language access and the policies of that specific state agency. Another important change that was made in the budget bill relates to bail and discovery. Now, I know we can talk about the bail and discovery reforms that were initiated in 2019, tweaked again in 2020, and now tweaked again in 2022. So this is going to be a very high-level summary of these changes. We can always come back to this if needed, or you can reach out to me separately offline. But I wanted to start with the tweak to the discovery law, because on this particular provision, NYSCADV and domestic violence programs across the state advocated very closely with the governor's office to try to get this amendment made, and we were successful, which I'm really pleased about. So the issue at hand was that because prosecutors were having difficulty complying with the discovery law, many cases were being dismissed because of their non-compliance. So in situations where the prosecutors would turn over the vast majority of evidence to the defendant before trial, if one or maybe two pieces of evidence didn't make it into that transfer, then the case could be dismissed, even if a substantial amount of evidence had already been shared. So what this tweak does to the discovery law is it permits prosecutors to be substantially compliant with the discovery law. So what does that mean? It means that if the prosecution turns over in the appropriate time frame the majority of evidence available, let's say they have 10 notebooks from police officers who were at the scene, but they don't have the 11th. They turn over 10, they're not able to obtain, for whatever reason, the 11th notepad. Then that would be viewed as being in substantial compliance. Or if there's a piece of evidence that the prosecution that might exist in two different formats, maybe there's a transcript of a conversation and an audio tape of the conversation. If the prosecution turns over the transcript, but for some reason can't turn over the audio tape, that is still viewed as being substantially compliant. Now, the reason why this impacted domestic violence cases so significantly is because in many criminal cases, an order of protection is issued at the time of arraignment. When these cases were dismissed, if there was an order of protection that was issued connected to that case, then that would no longer be a valid order of protection. Sometimes we were hearing that survivors weren't even aware that their order of protection was no longer valid. Sometimes we've heard that the perpetrator ran into family court to obtain their own order of protection against the victim before the victim even realized they no longer had a valid order. So we're hopeful that this change will permit these cases, particularly domestic violence cases, to continue and not be dismissed for some insignificant violations of the discovery law. Now, with respect to the bail changes that were made, earlier courts could consider whether there was a violation of an order of protection. These new tweaks make clear that it doesn't necessarily have to be a valid order of protection. It can be no longer valid, and it's still something the court can consider. They can still consider a history of firearm use or possession, but now they can also consider if there is the potential for serious harm to other individuals or the criminal history of the individual, whether there was a violent felony that had been committed in the past 5 years, or if there's significant criminal history that would lead the court to believe the individual might reoffend. And also, if there's a clear and imminent risk of flight based on the individual's past failure to appear. Some additional changes include making repeat offenses subject to arrest and making those offenses eligible for bail. Same with gun-related offenses, hate crime offenses, and subway crimes. Those offenses are now subject to arrest instead of an appearance ticket. Certain gun-related offenses are now eligible for bail. And the changes make it easier for prosecutors to go after perpetrators who are trafficking guns. There were tweaks to the raise the age statute that I just wanted to take a moment to describe. So you likely recall that the raise the age law was signed in 2017, and it essentially raised the age of adult criminal responsibility in New York to 18. Since then, there's been some criticism that the state has not increased capacity of the juvenile detention facilities where these young offenders go to obtain services. And in fact, the state has only spent $270 million of the $800 million that was initially appropriated when the law was initiated. So these new changes permit gun possession cases to be kept in criminal court rather than being transferred to family court, regardless of whether the weapon was displayed or not. That was something that the prosecution had to prove in the past. And the new proposal gives criminal judges the authority to access family court records. and all parties to look at the family court records when they're setting bail or determining appropriate resources for the individual or making recommendations on sentencing. And finally, it grants the family court jurisdiction over any individual who's charged with committing a crime before the age of 18. There was a little bit of a gap in the earlier law. There wasn't clear jurisdiction of those individuals, so this clarifies who is responsible for that court proceeding. Now, I did want to mention one proposal that was not approved in the final budget. This was a proposal that was introduced by OPDV, and it would have required a 40-hour training requirement for all domestic violence advocates. And there was an associated appropriation that was tied to the proposal, which was for OPDV to establish a training institute in order to develop and perform the training. NYSCADV didn't have any collaboration with the state on this proposal before it appeared in the governor's executive budget. Our understanding is that our sister coalitions didn't as well. Collectively, the coalitions had some pretty significant concerns about this proposal because we are federally designated to provide training and technical assistance to the state's domestic violence and sexual assault programs. So we did oppose this proposal, and we opposed the appropriation as well. So this was not something that was approved in the final budget. So I think that takes us through our discussion of the budget. I'd like to just ask Brittany if there's anything in the chat that I should be responding to before we move on to legislation.
So nothing in the chat, but we do have a question about the proposal that would increase the award amount of essential personal property from $500 to $2,500. When will this go into effect, or will it?
That is in effect right now. So that is effective right now. Okay, so, and I see, do repeat offenses for bail consideration include misdemeanors? Ness, I'd have to check on that. I'm not quite sure of the overlay of the repeat offenses with the bail eligibility. So I'd be happy to check on that and get back to you.
You have one more question, Joan.
Yes.
Regarding bail and discovery reform, when do these changes go into effect, and who is responsible for training criminal court judges on these changes?
Well, I'll take the latter one first. I believe it's up to the Office of Court Administration to train the judges on these changes. Again, I'd have to check on the implementation. My sense is it's effective right now, but I do want to check because it does relate to the discovery law. There might be a delay for OCA to promulgate some rules about it. So that's, I just need to double check on that. So moving on now to look at some of the legislation that the legislature and governor have worked on in 2022. We're going to start with the new laws. So these are pieces of legislation that were approved by both the Senate and Assembly and have now been signed by the governor into law. And this was a pretty productive legislative session. All told, there were just over 1,000 bills that passed both chambers. That's about 100 more than last year. The governor has only acted on just less than half of them. So she still has quite a bit of work to do. I suspect we'll see many of those bills passed after Election Day in November. So the first new law I wanted to bring to your attention is one you might be familiar with. OPDV focused on this new law during one of its calls with domestic violence providers, which enhances protections for survivors under the human rights law. So just for some context, back in 2009, domestic violence victims were included for the first time in the human rights law under the employment provisions, specifically the employment provisions. That was expanded in 2019, where domestic violence survivors received a new accommodation under the human rights laws, essentially to take a reasonable amount of time off in order to obtain services, counseling, whatever it might be related to domestic violence. And it also prohibited employers from asking an individual about their status as a domestic violence victim. So a very important change in 2019. Now, this is even a bigger change because it adds domestic violence survivors to all of the anti-discriminatory provisions in the human rights law. And there are many. They relate to employment agencies, labor organizations, training and internship programs, use of public accommodations. It applies to owners and landlords of housing and of commercial space. It even applies to those who are trying to get credit in order to purchase property. So in all of those provisions and more, domestic violence survivors are included as a protected class. I also wanted to point out that the way that this law is crafted, it's actually constructed in a very liberal way. It's called liberal construction. So that means that even if there's a protection that is not specifically enumerated in the statute, if it really holds up to the genesis of the law, if it serves a beneficial interest to those who need protecting, then it can apply. So in other words, if a domestic violence survivor believes that they've been discriminated against by an entity that's not explicitly mentioned in the statute, they can still file a claim because it's the intention to protect domestic violence survivors and others from all types of discrimination. Now, we heard from the Division of Human Rights that they are working on a guidance document to identify examples of inappropriate discrimination. So we'll be sure to circulate that to everyone when it's released. The next new law I wanted to bring to your attention, you might have heard something about this, is the Adult Survivors Act. This is one of our 2022 priorities, and we are thrilled that it was signed into law. And it creates a one-year window for adult survivors who experienced sexual assault prior to 2019 to file civil action. So why 2019? That's the year that New York State extended the statute of limitations for a select number of sexual offenses. So after 2019, these individuals already have the right to file a civil action, but there was no provision for retroaction in the 2019 law. So this is what this bill essentially does. If someone is a survivor and they experienced abuse, a sexual assault as an adult prior to 2019, then they will have a one-year window to file a civil action for justice. And that window opens on November 24th of this year and extends for a year through 2023. The gap between the passage of the law until November is for the courts to prepare for the filing of cases within the window. You might remember that when the Child Victims Act window was in effect, there were dozens of claims that were filed, and the courts were a little overloaded. So this is trying to prepare in advance for what they think might be a significant amount of filings. There were quite a few new laws that related to human trafficking. The first requires law enforcement agencies and district attorneys to inform victims of the availability of online information that could assist them, particularly relating to social or legal services. And the new law also requires law enforcement and DAs to offer to connect the victim with these service providers if the victim requests it. There are several new laws that relate to the posting of human trafficking information in numerous venues across the state. This includes adult entertainment venues, Port Authority airports and bus terminals, commercial airports, truck stop bathrooms, throughway bathrooms. It's really pretty extensive. Chapter 393 relates to training for hotel and motel staff. So this is training in human trafficking recognition, and the training has to occur within the first 60 days of employment. And the new law requires DCJS and OTDA to develop the training, along with the Interagency Task Force on Human Trafficking. And another new law relates to training for bartenders on human trafficking awareness. So the human trafficking components will now be incorporated within all 34 bartending courses recognized by the New York State Liquor Authority as part of its alcohol training awareness program. Two new laws also about identity theft. Of course, we know identity theft is a form of financial abuse and occurs in almost all domestic violence cases. I think a recent study said 99% of domestic violence cases include some type of financial abuse. So the first new law incorporates identity theft into the state's definition of elder abuse. And this is important for those victims to be able to obtain support services and participate in programming. The second new law simplifies the procedures for a victim to essentially raise their hand and say, I'm a victim of identity theft. Individuals no longer need to report their crime to the police in order to establish that they've been a victim of identity theft. Now, victims will be able to self-attest to their status in order for a creditor to cease collection activities as there's a review of that case. So that's really an important change. It also allows victims to present documents from courts, whether it's family court or criminal court, to document that a crime was committed. You may have heard that there were two pretty weighty packages that were passed over the course earlier in the summer. One package related to firearms and the other related to abortion protections. I'll get to that in a moment. With respect to firearms, this is again kind of a simplified take on the package, but I did want to make you aware of these new laws. The first closes a loophole in the penal law related to large capacity ammunition feeding devices by no longer requiring prosecutors to prove the date of the manufacture of the weapon. I guess that was difficult for, or even impossible for prosecutors to determine. The second makes it illegal for individuals, for most individuals, to purchase or sell body vests. It does exempt active law enforcement officers, firefighters, or first responders, or anyone who's employed in an occupation which requires the use of body vests. Another new law redefines the definition of a firearm. Some of these weapons are doctored to expel projectiles via an explosive. So this now includes those types of weapons within the definition of a firearm. And New York State has taken action to ensure that anyone under the age of 21 cannot legally purchase a semi-automatic rifle. So that becomes effective as of September 6th, and also relates to any transfers of ownership of those weapons. Finally, and this probably got the most attention, I think, in the media, were revisions to the state's concealed carry weapons law. And this now requires applicants to take and pass a firearm training course in order to carry a concealed weapon. It also excludes several sensitive locations where carrying concealed weapons would be prohibited. And that includes courts, churches, parks and playgrounds, nursery schools, colleges, public transportation, public sidewalks, arts venues, gaming and sports events, polling places, even Times Square. So I really question where it will be legal to carry a concealed weapon, because it is a very extensive list of sensitive locations. Another element of that new law expressly requires property owners to approve a person possessing a weapon on their property. So that kind of possession of a concealed weapon on someone else's property is not implied. That property owner has to give express permission to an individual to carry a concealed weapon on their property. So now moving on to the reproductive health package. We certainly saw this come into play after the Supreme Court took its very drastic action to reverse Roe v. Wade. And this is a really solid package. I'm sure the legislature will be working on additional laws in 2023. But the first creates a new cause of action for the unlawful interference with protected rights. And this would arise when a person demonstrates that they performed a lawful procedure or tried to perform that procedure, which ultimately resulted in litigation or criminal charges against that person in court. There was also another law that enhanced protections for abortion providers by creating a statutory exception for their extradition. So if another state where abortion is illegal attempted to have discovery or subpoenaed a doctor in New York State, this would preempt that. They would not have to participate in those out-of-state proceedings. There's a new law to prohibit disciplinary charges against abortion providers, and this is specific to doctors who provide services to patients who reside in states where abortion is illegal. There's also a new law to prohibit medical malpractice insurers from taking adverse action against abortion providers. Now, abortion providers, employees of service providers, volunteers, and even patients can be eligible for the state's address confidentiality program, where domestic violence survivors are already eligible. And lastly, there's also another law. It wasn't really part of the other package, but I wanted to mention it, which is a study of the unmet health and resource needs of pregnant New Yorkers that will also look at crisis pregnancy centers and the ability of women who go to those centers to obtain accurate, non-coercive healthcare information and timely access to services.
Hey,
So I
Jen,
want, yes.
we have a quick question about concealed carry. Someone thought this was successfully challenged as non-constitutional. Is this still enforceable?
My understanding is it is, but I would need to check on that, Allison. I would need to check. I'm not really an expert on the weapons laws, so I'm happy to check for you. Some additional laws that just should get some notable mention. There were two new laws that were proposed by OVS that relate to compensation eligibility. The first makes victims of unlawful dissemination of photos eligible to get victims' compensation. And the second allows victims of reckless endangerment, either in the first or second degree, to also be eligible for victim comp. Another new law is really a clarification of a law that was approved last year regarding the provision of free menstrual products in temporary shelter. And it defines what is meant by temporary shelter. We knew it included domestic violence shelters and family shelters, but it also includes hotels and emergency apartments as well as safe houses for refugees. There's a new law that expands the group of healthcare professionals who are authorized to file extreme risk protection order applications. So this now extends to licensed clinical social workers and master social workers, physicians, psychiatrists, mental health counselors, all types of nurses. And it also requires the police and district attorneys to file an ERPO application when they're presented with credible evidence. And it requires the state police to promulgate rules for everyone, but particularly police, on when to file these applications. There's a new law to create a transgender and gender non-binary wellness and equity program under the AIDS Institute. And this is the entity that would fund grants to organizations that serve people that identify as trans or non-binary or intersex, if those grants are appropriated. So that's a pretty big if. There's a new workplace sexual harassment hotline that will be run in the state by the Division of Human Rights and staffed by pro bono attorneys. I'm not quite sure if that hotline is available just yet. I'm not sure. And another new law would prohibit the release of personnel files in retaliation against employees who complain against discrimination. This was an issue that arose as a result of the sexual harassment complaints against former Governor Cuomo. And it authorizes the Attorney General to investigate any cases when an employer has been or is about to retaliate or discriminate against an employee. A new law requires social media platforms to collect reports of hateful conduct. And this is conduct that is intended to vilify or humiliate or incite violence against a group of people. And it also requires these platforms to provide a direct response to anyone who reports this kind of conduct. I thought that was a really important provision because it's not like you just sort of submit a form, a complaint, and you never hear back on the status or what's happening as a result. There's a new law to require non-regulated camps to perform staff background checks, which is a good new law. And a new law to increase the number of judges in some judicial districts and family courts. Specifically, there'll be 4 new family court judges in New York City, 1 in Nassau, and 2 in Saratoga County. And there will be 1 or 2 new Supreme Court justices in each judicial district in the state. And this is, of course, an attempt to relieve some of the overload in courts. So I'd like to move on now. I'm being a little careful with the time. I see it's already 10 to 11, to the bills that passed both chambers, but are awaiting the governor's action. So like I said, she has, unless the bill is delivered to the governor, then she has a limited, I think it's 15 days to take action on the bill. But if the legislature doesn't send the bill to the governor for action, then she has until the end of the year to either sign the bill into law or veto the bill. So a couple of firearms bills that I wanted to elevate for you are specific to when an order of protection is issued. As you know, courts must order a surrender of weapons when an order of protection is issued if there are certain risk factors that are present. Sometimes a defendant willfully refuses that order and doesn't surrender their weapons. So in those cases, or when good cause is shown, the court has the discretion to order an immediate search and seizure for those weapons. This bill, if signed into law, would require courts, so essentially remove their discretion, to order this immediate search and seizure when a defendant willfully refuses to surrender them. So we think this is a very important bill and hope the governor signs it. In a similar vein, A new bill would require the criminal court, when an order of protection is issued, to ask the prosecutor and defendant about the existence and location of firearms. In family court, when an order of protection is issued, the same inquiry would be made of the petitioner and respondent. But one of the important amendments about this bill that we advocated for and was added to the legislation is that if this occurs and the family court makes this inquiry of a petitioner, that would happen outside the presence of the respondent. We were a bit concerned if the court asked a victim about the existence and location of firearms in front of the alleged perpetrator, that could elevate harm, the potential for harm to that victim. So with that change, we now support this bill and hope the governor signs it. Health insurers already are required to permit domestic violence survivors to use alternative contact information for any information pertaining to the services that they obtained or for billing purposes. But in order to receive this accommodation, domestic violence survivors have to provide an order of protection. This bill, if signed, would permit survivors to make that request in writing, so essentially to self-attest without providing the order of protection. And they would merely have to say that disclosing the information could endanger them. So this would prohibit the insurer from disclosing contact information, personally identifiable information, or the nature of the covered services to the policyholder. And that would remain in effect until the victim told the health insurer they no longer wanted that alternative contact information to be used. One of our 2022 priorities was a bill to make it a bit simpler for domestic violence survivors to break contracts with phone, television, and utility businesses or contracts, particularly the bundled or family plans. We've had a little bit of a change of thought about permitting victims to self-attest to break these contracts, and here's why. We became concerned that abusers might misuse this accommodations and present themselves as the victim to these businesses to break themselves from these contracts, leaving victims essentially holding the bag of the contract. So whatever financial requirements were in that contract, it would be up to the victim to then, satisfy. We've reached out to the bill sponsors to have some communication about our concerns. I think they understand where we're coming from. This is a little different than some of the other accommodations that we've been advocating for advocates, for survivors to be able to self-attest, because it has this financial element to it. We don't want victims left, essentially being the only person tied to the contract. So we think we will find a resolution with the bill sponsors as a chapter amendment. So that's essentially an agreement between the governor and legislature that is made to amend the bill in the following legislative session. So we'll see how this plays out. But there are some other important provisions to this law that will not be changed, which is restricting companies from setting restrictive conditions on individuals seeking this accommodation. And this could be conditions like requiring arrears to be paid, or prohibiting victims from obtaining a new phone number, or even requiring approval by the primary account holder. And there's another provision in the bill that would permit self-attestation for a victim to get an unlisted phone number without any fees. So that's something that we'd like to see pass without change. So we'll keep you apprised on the status of this bill. There's a bill to create a new crime if an image is disseminated without a victim's consent, and it was disseminated with the intent to degrade or abuse the victim, to cause harm to their emotional, financial, or physical welfare, to them or their family, or for the actor's own amusement, entertainment, or profit. And this would essentially provide the victim and the family with a right of action within 3 years of that dissemination. This also importantly would allow victims to pursue court orders to require websites to permanently remove the images from their platforms. And this is very challenging currently for victims to do. So we're really hoping that this bill gets signed into law. There's a bill to require domestic violence and child abuse training for forensic child custody evaluators. Currently, there are no standards, certification, or training requirements for these professionals. And this was one of the recommendations of the Blue Ribbon Commission on Forensic Evaluations, which NYSCADV participated on. So this bill would require biennial domestic violence and child abuse training for anyone who wanted to serve as a forensic evaluator. The specific number of training hours are not determined in the bill. That's kind of left to when the training is developed, but there are specific training topics included in the bill, and these shouldn't be a surprise to anyone on the call. Case law and statute, dynamics of domestic violence, coercive control, power and control tactics, monitoring of victims, and litigation abuse. It's really a quite defined list of topics. And the bill would require OPDV to contract with NYSCADV to develop and provide the training. And that training would be reviewed and updated every 2 years. Earlier, I talked a bit about some funding that was in the state budget for the storage of rape kits before a criminal proceeding is pursued. Now I'd like to talk a moment about the tracking of sexual offense evidence collection kits when criminal procedures, when criminal proceedings are pursued by the victim or the state. So this would create a similar tracking system for those evidence collection kits that would track the location and status of the kit throughout the criminal justice process. So that includes the initial collection, the receipt and storage at a law enforcement agency, the receipt of the kit at the lab, and the storage and use, the destruction of the evidence after it's been analyzed. This would permit survivors to anonymously access information about the status of their kit at any stage. And it would require DCJS, along with DOH, OVS, the state police, and NYSCASA, our sister coalition, to develop the tracking system. So DCJS would be responsible for developing the rules that would ensure both untested and tested kits are trackable and entered into the system. All the entities who essentially have custody of the kits at any time would be required to participate in this tracking system. Now, I do want to point out that there was no appropriation attached to this bill. So if the governor does sign it into law, an appropriation would have to be, I think, would have to be assigned next year during the state budget process in order for this tracking system to be developed. Now, some notes on some other important pieces of legislation. Expanding eligibility for home visiting service to those services to those on public assistance who are already exempt from work activities. There's a bill to increase the severity of sexual conduct against a child in the 3rd degree. There is a bill to permit electronic submission of public benefits, the documentation to support that application. So that would be a very important change, I think, for domestic violence survivors, as well as a bill to extend the length of time that an individual could obtain childcare assistance from 12 months to 24 months. Again, these are bills that passed both chambers that are awaiting governor action. There's a bill to permit sexual violence victims to have their voter registration records kept confidential. This is an accommodation that is already extended to domestic violence survivors. And a bill to create a new youth services unit in the Port Authority Police Department to provide services to at-risk youth. There was a pilot project, I think that was pretty successful, that was focused on at-risk youths in Port Authority buildings. So this would make that pilot essentially permanent. And there's a bill to require community supervision programs to not conflict with an individual's employment or educational schedule. So that's a really important bill. You know, certainly we want these individuals to be employed or to continue going to school. So this would be a great bill if signed. There's a bill to establish an Office of Racial Equity and Social Justice that I wanted to let you know about, as well as a bill to create a statewide campaign focused on the acceptance, inclusion, and understanding of diversity. There's a bill to prohibit discrimination based on citizenship or immigration status in the human rights law. And two important bills relating to LGBTQ individuals, one that would study the employment rate of transgender New Yorkers, and another that would establish an LGBTQ plus advisory board in New York State. So I think at the end of the legislation, that was a very heavy lift for me to run through. Brittany, is there anything in the chat, any questions I should try to address before we move on?
Hi, Joan. Yeah, two questions. The first of which is, can you explain the difference between rape kit and the SOECK kits?
Yes, the kit themselves, my understanding, and please someone correct me if I'm wrong, the kit itself is the same. The difference is where the kit is situated in the criminal process. And this is the way the state envisions this. So if a victim goes into a healthcare facility and has an exam and a rape kit is performed, but that victim does not yet want to pursue a criminal proceeding, then that kit is not yet viewed as evidence. Based on the law from 2018, that kit has to be stored in New York State by an entity for 20 years, thinking that at some point the victim might change their mind and decide to pursue a criminal proceeding, at which point that rape kit would be analyzed. So those are rape kits that are not viewed as evidence. A sexual offense evidence collection kit is the same kit, but it's when the victim decides to pursue a criminal proceeding. So that kit gets sent to a law enforcement agency and then a lab of the state to be analyzed to support the criminal proceeding. So that becomes evidence to support the state's case against a perpetrator. And that's in SOECK. And that relates to the bill that was passed this year to create a separate tracking system for those kits that are analyzed as evidence. Now, I know many of you are thinking, how is this possibly going to work to have two separate systems to track these kits? One supervised by OVS for these kits that are not yet evidence, and the other supervised by DCJS to track kits that are evidence to support a criminal proceeding. Let me assure you, I have the same questions, and we're just going to have to see how this all plays out. It is on my 2023 look ahead as something we're going to need to work with the state and the legislature and our friends at NYSCADV to try to figure out how all of these moving parts work together.
Thanks, Joan. Another question that came up is regarding family court judges. There's an understanding that there was no funding attached. So do we know how these judges will be hired?
I do not know that, and thank you for elevating that. I think I failed to mention that. It is not unusual for the legislature and governor to approve legislation that has a fiscal impact, and then deal with that fiscal impact in the next subsequent legislative session. So I'm not going to commit to this, but I would imagine this will be discussed as part of next year's state budget process.
And finally, we have one question regarding training for forensics. Does the training for forensics include training examiners in risk and safety? And can that be added to the bill if it isn't included?
It does not currently include them. It is focused expressly on forensic child custody evaluators. That might be something we can look at doing in 2023 as a separate bill. But I think it's too late to add that into the current bill. So I think I'm going to move on to our 2023 legislative look ahead. This is really just Brittany's and my predictions on what will be top of mind in 2023. We could be spot on, we might be wrong. We certainly expect issues to arise during the course of session that we didn't anticipate, but we did want to give you a sense for what we think will be, some of the issues that are discussed during next year's legislative session. And of course, at the top of the list is those OVS VOCA cuts. As I said earlier, we understood OVS provided information to the governor's office that suggested with $14.4 million additional, they would be able to keep victim assistance programs whole for the first year of the contract term. It is a 3-year contract term, and we certainly anticipated having to work with the governor and legislature in years 2 and 3, essentially next year's budget and then the 2024 budget, to get additional funding for those additional contract years. But now what we're seeing is some victim assistance providers, and this is across really the entire community of victim service providers. We're not hearing that any particular type of program was impacted more than others. But from the research that NYSCADV has already done, and this is pretty preliminary, it looks like programs received cuts anywhere from 7% up to 30%. This is just not sustainable. We cannot continue to have cuts like this and provide services to the vast and increasing number of survivors looking for assistance year over year. At what point are we not going to be able to provide quality services? What program can sustain a 30% cut to their primary funding source? So this is something that is urgent that we resolve. We have already elevated it to the governor's office. We have foiled information from OVS. We know our other partners have foiled information as well to try to determine the specific cuts that were made and to try to understand why. When OVS was estimating before they got the additional funding appropriated that programs would be cut 10 to 15%, we got $14.4 million, which OVS requested, and now programs are cut 25 to 30%. That just doesn't make sense. So we need to find out more information, but we need programs to be sufficiently funded to do the work that New York State requires of us, right? These are services that are required of our programs. So more to come on that. I will get off my soapbox, but if anyone wants to talk more about the coalition building that's happening, the advocacy on that, please reach out. I'm always happy to talk. We're also going to be looking very closely at any opportunities to include a COLA increase or increased pay or bonuses for domestic violence advocates. And we want to continue our work to push the state into assessing and transforming our domestic violence funding model based on a per diem reimbursement. We know it's no longer survivor-centered. We have $15 million in this OCFS pilot that we hope can be performed soon so that we can keep the progress going forward. There's been a lot of discussion, a lot of evaluation. With the community's input, NYSCADV has put together recommendations for the state on what a new funding model would look like. We just have to continue the work. In terms of legislation, one of our 2022 priorities is the Fair Access to Victim Compensation Bill. This passed unanimously in the Assembly. We were thrilled to see that happen. Unfortunately, it didn't get to the Senate floor for a vote. And this is the bill that would eliminate the requirement for victims who are hoping to receive compensation to report their crime to the police. This would allow those victims to self-attest to the crime and also expands other types of documentation that could be presented. It also extends the time frame for individuals to file claims for compensation from 1 year to 3 years. So some important changes there. Another priority for NYSCADV in 2022 was a bill to have the state fund internet services for all shelter residents, not just limited to domestic violence shelters, but all shelters. According to a 2020 report, only 6% of homeless residents received internet access while in shelter. So this would require the local DSS to provide and pay for internet services in shelters and then seek reimbursement from the state. And again, another priority of ours that we continue to push and push and push is the Healthy Relationships K through 12 curriculum bill, or otherwise known as comprehensive sex ed. And, we know that nationally, more than 2/3 of teenagers who've been in a relationship report experiencing some form of sexual, physical, or emotional abuse. Comprehensive sex ed teaches students about bodily autonomy, personal boundaries, privacy, and how to tell the difference between a healthy and unhealthy relationship. And all of this would be age appropriate, which I know all of you know. So we're going to be continuing to push for passage of that very important bill. I did want to mention the Equality Amendment Resolution, which was passed during the the special session earlier in the summer. And the resolution passed both chambers, but unlike the other legislation that we've been talking about, this resolution does not go to the governor to be signed. It actually has to be approved by next year's legislature, and then it goes to the voters for ultimate approval. And this resolution would solidify abortion access in New York State by essentially adding ethnicity, national origin, age, disability, and sex to the state constitution. And that sex includes sexual orientation, gender identity, gender expression, pregnancy outcomes, and reproductive health care and autonomy. So those provisions, those protections would be added to the existing protections that cover discrimination based on race, color, religion, or creed. So we were thrilled that this passed in the legislature in 2022. Again, it has to pass again in 2023 or 2024, and then go to all the voters for passage. We already talked about the rape kit storage and tracking systems, so I'm not going to discuss that again. But I would like to mention the Clean Slate Act, which passed in the Senate, but not the Assembly. And this would automatically seal certain convictions after a certain passage of time, either from after the imposition of a sentence or the release from parole or probation, assuming that the defendant doesn't have a current charge pending. And a version of the Clean Slate Act was actually included in the executive budget by the governor. That version didn't get approved in the final budget, but there is a piece of legislation, this A6399C, which essentially covers the same ground. It does have a few variances in it. So we think there'll be a lot of discussion about the Clean Slate Act again next year. And I wanted to just give a word on the work that NYSCADV and others have been doing with respect to trying to improve outcomes in family court for domestic violence survivors and their children. There's been a number of bills introduced since the Blue Ribbon Commission on Forensic Evaluators concluded their effort. We are deeply involved in all of these pieces of legislation. I just wanted to get them up on a slide for you, so you had it handy. But the first is Kira's Law, which I think most of you are probably familiar with. This really enhances the statutory definition of best interests of a child for the purposes of child custody or visitation, really with the goal of elevating the child's safety during very lengthy family court proceedings. And there's still a bill that is focused on supervised visitation. I think it needs to be tweaked a little bit to sort of align a little better with Kira's Law, but the goal is still a good one, which is to ensure that there's a consistent approach to supervised visitation programs across the state. I also think there's a very, very clear need for appropriations for supervised visitation programs, as well as safe exchange programs, which we might be talking to the state about as part of the budget process. There is the bill to provide access to the parties of a proceeding to the child custody evaluator reports. Right now, access to those reports is very inconsistent across the state. In some areas, litigants are not provided access, only litigants counsel. So that's a bill that we support, and we'll continue to talk to others to try to get that to progress. Two bills that, well, actually the remaining four really came out of the Blue Ribbon Commission. One is to eliminate forensic child custody evaluators completely from custody proceedings. And the other is to set a moratorium on their work until all of the, I think it was 11 recommendations of the Blue Ribbon Commission, excuse me, are implemented. So two important bills there. And a bill to prohibit forensic evaluators who have been removed from the mental health panel or from other bodies who would approve forensic evaluators from appearing as expert witnesses. We know of at least one case where an individual was removed from the downstate mental health panel and then was serving as an expert witness in the case where he had already interviewed the parties. We don't think that's appropriate. And finally, a bill to eliminate immunity for forensic child custody evaluators, because no other professional within the courtroom has this quasi immunity. And there is a question on whether it should be extended to forensic child custody evaluators. So I know we have 10 minutes. I think that gives us some time for questions. But before we get to the questions, I just wanted to let you all know that we have our dates for our next 2023 lobby days. We have a Budget Advocacy Day on February 14th. I don't know if we'll be wearing purple or wearing red for Valentine's Day. But we also have our Legislative Day of Action on May 2nd. And right now, both of these events are planned to be in person. We have spaces reserved in the Legislative Office Building. We have that great wall space preserved for Day of Action in May. So we hope you get those on your calendar so you can all join us. So questions, Brittany, anything I need to address?
So we have one question. Are there any updates on advocacy around COLA and retention bonuses for staff?
Well, as I mentioned, we do anticipate this being part of our advocacy efforts going into the 2023 budget process. I don't think I have anything specific to report out just yet, but we will be talking to programs and advocates to really understand what would be most helpful, to get your views on, whether it's an increase, a COLA, whether it's bonuses, so that we can advise the legislature and governor. I think it's going to be a little bit of a heavy lift, but I think we have to try. Thank you for the question. Anything else?
So we have a question. In the human rights legislation, what documentation does a survivor need to provide to demonstrate their status?
I'm not quite sure about the documentation. I understand that the Division of Human Rights has a fairly simplistic form that can be completed by any individual, any New Yorker who feels that they have been discriminated against. And that will, I should have mentioned, I think this was on my slide, but if that form is submitted through the Division of Human Rights, then the individual does not need an attorney to file that form. And I think it does initiate a review and potential investigation of the claim that is made. So I think in that conversation with the Division of Human Rights, they will inform the individual of the documentation that would be needed based on the specifics of the claim. But I'm not aware of any specific language in this proposal this year that speaks to the particular documentation for domestic violence victims. Well, I want to encourage everyone to reach out. Here's my name and email. I think email is the best way to get in touch with me at this point. Happy to talk with folks about any of the legislation presented. We didn't want to flood the chat with giving you copies of all of the legislation and the budget bills for sure. But if there's anything that you have a particular interest in, you'd like to see the bill language or the budgetary language, just let us know. Reach out to me or reach out to Brittany and we can get you what you need. And, we certainly commit to keeping you all apprised of our advocacy efforts, particularly on the VOCA cuts as we go through these next couple of months, but then certainly into next year's legislative session.
Joan, we have another question that came in. Have we ever received any information based on original FOIL requests on OVS cuts as to the original assessment?
Let me answer that this way. We did FOIL from OVS the prior awards. So we know every program that received funding under the 3 different RFAs that existed before this most current RFA. So that would be for VAPs generally, for legal services, and for case managers. So we have every program that received an award, the value of that award, and in addition to that, the 2 entities that received sole source contracts from OVS. What we don't know is how OVS computed its $14.4 million projection that was provided to the governor. Our understanding, we have an email from Elizabeth Cronin that amount of funding would have kept programs whole for the first year of the contract. And it assumed that additional funding would be appropriated in the next 2 budget years for the subsequent 2 years of the contract. But we don't have anything in writing that would substantiate how OVS calculated that was the amount of money they needed to keep programs whole, or I should say, to keep level funding, right? Because we know that programs have been insufficiently funded for years. And I don't like this concept that, somehow we are sufficiently funded, because we're not. So the most that OVS could have done was to maintain funding. But that, of course, doesn't look like it happened. I hope that answers the question.
And one more question about the sexual assault kits. Can the police access the kit for another criminal investigation, or is it only accessible by the victim?
I think the new tracking system would have to determine the specific protocols for those types of scenarios. This is a bill that hasn't even been signed by the governor yet, so the tracking system doesn't exist. It is in DCJS's court to create that database along with other entities. So I think those are the types of, very specific scenarios that would have to be described in their policies and protocols.
How going forward can, let's see here. How can advocate numbers to the legislature? Let's start with this one. So a DV victim has to provide any document for unlisting phone numbers. If so, what type of document?
That would be a self-attestation. So they would just have to, write essentially a note that says, I attest to being a domestic violence survivor, a victim of domestic violence, and I would like this accommodation. So that's a self-attestation. But again, that's just a bill. It has not been signed into law. I do want to be cognizant of the time. My clock says 11:29. I just wanted to take this opportunity to thank everyone for being here today. I think we had over 100 folks here, so that's really fantastic. Please reach out, have a great rest of your summer, and I'm happy to hang on a couple more minutes to see if more questions come in. But thank you to those who want to jump off. I see Daniela is asking if I can share the info on forensic evaluators again. I'm not quite sure if you're looking for the training bill, but I can do both. So here's the slide, and we're happy to provide the slides to everyone that discusses the training for forensic evaluators. This is a bill that has passed both chambers, but has not yet been signed by the governor into law. And this would require that anyone who wants to serve as a forensic evaluator, so licensed psychiatrists, psychologists, and social workers, to obtain training every 2 years on domestic violence and child abuse. And it essentially requires OPDV to contract with NYSCADV to develop and provide that training. The training, of course, would be reviewed on a regular basis and updated as needed. And there are very specific topics in the bill that must be covered as part of the training. And I imagine that NYSCADV would be bringing, others in to help with the development of that training. And then we also have some additional bills that have not passed the chambers, but these relate to eliminating the roles of forensic evaluators entirely, replacing a moratorium on their work until all of the recommendations of the Blue Ribbon Commission can be implemented. There's a bill to prohibit forensic evaluators from appearing as expert witnesses, and this applies specifically to forensic evaluators who can no longer serve as a forensic evaluator, essentially a bad actor who tries to appear as an expert witness once they can no longer serve as a forensic evaluator. And then another piece of legislation would eliminate quasi-immunity for forensic child custody evaluators. So I hope that answers the question. Carla, what I was referring to, I see your question, can I provide the statute or other legal requirements stating our services are mandated? What I was referencing was the emergency core services in the rules and regulations for licensed programs. So that's what I was referencing. Parts 452, 453. Right, I think if that's it, we'll go ahead and close today's webinar and thank everyone again for participating.